Okay, good evening, ladies and gentlemen, and welcome to Thursday night's construction roundup, where we are speaking to Richard Silver, senior partner, and Mohammed Haq, who is consultant barrister, adjudicator, and quantum expert, and of course, Mr. John Sharp, who is consultant solicitor and insurance expert. So we've had some pre-submitted questions. I'm going to introduce each of the guys and then going to have a chat about what things they've been looking at in the last couple of weeks. So, firstly, Richard, I know you've been the ongoing impact on the construction industry from the Grenfell situation.
Yes, Julie. Obviously, a terrible tragedy. It's surprising, actually, that it was back in 2017 that it occurred. It seems like only yesterday. And we've seen a lot in news and otherwise about the ramifications. The key point is there's been a lot of government reforms following the tragedy, and particularly the building amendment regulations that came into force on the 21st of December 2018. What this amendment did, and it is somewhat surprising when one thinks about it, it prohibits the use of combustible materials on external walls where the building is in excess of 18 metres in height and the building contains one or more dwellings. I suppose it's questionable why you even had to have such an amendment. It would seem quite obvious, and indeed many countries did prohibit combustible materials in such buildings, but not, it would appear, in the UK. So this new amendment will apply to such things as housings, hospitals, residential care premises, and the like. It applies to new buildings, refurbishment buildings, where those buildings are being refurbed with regards to the external walls of those buildings, and for any building where it's going to have a change of use and fall within the amendment regulations. Additionally, there was an advice notice in January 2020 published by the government, and what it said was that any owners of such multi-storey, multi-occupied buildings, that they should investigate the risks of their external wall systems prior to any regulatory system to be reformed. So no surprise, and we're only too aware that many building owners are at the present looking into their buildings, and what they are finding is that many of the external walls do contain combustible materials, and that's what we've seen regularly on the news each evening. Very, very concerning. Now, the government has made funding available to try and assist in having these works properly rectified, but there is a problem. And the first problem is there is a limit on the funding. And from what I understand, the funding will cover at very best 1/3 of the buildings that require works undertaken and that are over 18 metres in height. It doesn't even go towards those buildings that are under 18 metres in height. And what this new funding requires, however, is that any owners do nevertheless pursue all reasonable claims that they may have against those that originally installed cladding. And that's what we're seeing. I am seeing a large amount of claims being commenced by owners of buildings against contractors and or subcontractors and or insurance companies. But what I'm finding is there are problems. And the first thing is that some of these buildings were constructed in a period over a period of 6 or it may be 12 years ago, and hence there is a limitation clause applicable. So what I would say to you, if you're listening and you believe that you fall into this situation, you need to commence your action as soon as possible to make sure you come into the required limitation period. And because it's latent defects, you've got 2 limitation periods. The first being under the contract under which the works were undertaken, or alternatively, the Latent Defects Act. The best scenario is under the contract, you're going to have 12 years, and under the limitations, the Latent Defects Act, is going to be a long stop of 15 years. So if you're outside of that, you may well have a problem. The next thing I found out is it seems that no one keeps contracts anymore or documents. So when they're looking to find out what people they were doing what work, they simply don't have it. So I've got a number of actions against subcontractors where the contractor is alleging defective works for certain elements, which my client didn't even undertake, because they simply don't know what the works that were undertaken. So that's the clear problem. It's understandable. Owners, contractors, employers, and the like are commencing action against anybody and everybody, because if in doubt and the limitation period is running, commence against anybody. I should add, though, however, if you're going to go after a negligence action rather than a contractual action, which would include under the Latent Defects Act, there's a problem with recovery of what is called pure economic loss, because a lot of the losses that are now being sought are to rectify the cladding. There's not been damage in itself, physical damage either to a person or property, and hence it is pure economic loss. And the current case law indicates that under a tortious action, you cannot recover it. So far as contractual actions are concerned, what most contractors, subcontractors are arguing is that they were complying with the relevant regulations that applied at the time, particularly approved document B. What seems to be the case is, however, that following the government advice note in January 2020, it seems that there's a possibility that you cannot rely upon that going forward. But being honest, at the moment, I don't know if that is correct, but it's going to come to a fore in the case being brought by Camden Council, which is going through the courts at the moment, and that is the defence that's being run. And no doubt the judgment will set out whether meeting approved document B is a sufficient defence. But in summary to your question, what is happening? Everybody is suing everybody else, and nobody knows who was meant to do what and why.
Wow, sounds like a complete mess.
It is, and it's a shocking situation to be in. You would have thought that the UK would understand if you're building a building 18 meters high, you shouldn't be using combustible materials for cladding. I mean, I saw Tower Inferno when I was 7 or 8. You would have thought everybody knew it.
Apparently not. Right. Okay. So, and I saw both John
Julie,
and...
can I just add to that as well?
Please do.
And insurers are being particularly unhelpful. They have now, in just about every policy that they are issuing to professionals, so surveyors, architects, they say, we want nothing whatsoever to do with fire, materials, etc. So surveyors are being even more cautious than ever before. And even in buildings that are less than 18 meters, they are still insisting on a fire certificate because they won't have the insurance cover.
Right. Okay. Mo, I know you've been looking recently at natural justice. Try that again. Natural justice in adjudication. Get the teeth in. What is this? What is it?
What is this? Yes. I mean, it shows Julie is not a construction professional.
Absolutely.
I'm sure the rest of the audience are all familiar with what is natural justice in adjudication. What is it? I mean, it's said there is little justice in the nature, but there is something called natural to the judicial system, adjudication being a tribunal, so they have to follow it. The rules are of two parts, that everybody is entitled to get a fair hearing, and no one should judge a case in which he's otherwise involved or has an interest. Now, today's discussion of mine is to do with rights to fair hearing, not the other part, which relates to conflict and all these things. We know that adjudicators are neutrals, and the act which created adjudication and the scheme under it specifically requires the adjudicators to remain neutral and be fair between the parties. And there are, of course, examples where they failed to do so. But my today's discussion is about a particular aspect which has become very popular in last 8 to 9 weeks. And I, as an adjudicator, faced it as well. This is about a restrictive view by an adjudicator on his own jurisdiction. What it means is, very simply, that if, and the context in which it has arisen recently is, that if a responding party in an adjudication sets up a defense which the adjudicator fails to consider, then his decision may not be enforced. So it's a serious thing for the adjudicators to take a note of. Now, interestingly, this is nothing new, but we had a kind of a period where nobody was doing anything or no court decision came in. Back in 2008, this has first been stated in a case called Quatlets and Honeywell Control Systems. The adjudicators, in that case, the adjudicator failed to take a defense where the responding party has raised a counterclaim by a set-off. And if the adjudicator had taken that into consideration, and if he decided in favor of the responding party, he would have awarded 25% less than what he did. And the court said, yes, it's a material breach. The adjudicator should have taken that into consideration, and he shouldn't have favored the referring party. And also the court mentioned that they took into considerations the referring party's submissions that, oh no, we have the right to set the adjudication. This is our adjudication. This defense has got no connection with what we have asked for and blah, blah. So they say this is a wrong tactical move. The decision was approved further again in 2009 and 2010. The 2010 decision of Mr. Justice Colson, as he then was, Pillen and Brer, is widely known that the defendant has every right to throw anything by a set-off, and the adjudicator should consider that. And after that, because the Pillen and Brer also stated that a decision will be enforced if the mistake is not deliberate and if the mistake is not material. In other words, if the effect of the mistake is not so big. And Colson J. also said in that case that he finds it difficult why a defense which was only to reduce 25% of the value would be treated as material. After that, it was kind of a full stop being given by Stuart Smith J. back in 2013, following the principles of deliberate inadvertence and material non-material. He rejected to the plea that he will not enforce because the adjudicator didn't consider a defense. And more or less, people started to think that it's a difficult thing to break and to get an adjudicator's decision not enforced on the ground of he failed to consider a defense. This was going on from 2013 to 2020. All of a sudden, the UK Supreme Court, in the case, which is obviously famous for other reasons, the Bresco Electrical v. Michael J. Lonsdale in 2020, very neatly said, however narrowly the referring party chooses to confine the reference, a claim submitted to adjudication will nonetheless confer jurisdiction to determine everything which may be advanced against it by way of defense. And any failure may cause the court to decide that the decision will not be enforced. Now, it's just a revival, and we have a decision at the late published around 2021 January, Global Switch States versus Sudlows. This is from the TCC. Fiona O'Farrell-J, delivering the judgment, has summarized the law and stated that A, the referring party's right is to bring a reference and define the scope of the adjudication from their point of view. B, the right of the responding party is to throw anything they want to throw, and every single defense been set must be considered. And she gave an example that, for example, if the referring party is only asking for a declaration, obviously a counterclaim of some money is no defense. But that doesn't mean that the adjudicator will not consider the defense. The adjudicator still will have to consider it and say that on this ground, I am rejecting this defense. So there is a responsibility, as well as she pointed out, that the referring party shouldn't be so interested to say that, oh no, it shouldn't take into consideration. That will have a bearing on the decision of the adjudicator as well. Now, my experience, and the reason I'm discussing this today, is we all know that a payment adjudication or an smash and grab adjudication, as is said sometimes, is something different. A dispute is completely a different dispute from a valuation adjudication. Now, after these two decisions in last 2 months, I've experienced that the responding party are valuing different elements of the same application for which the smash and grab has been raised, and then saying, because under this variation, this much is only the entitlement of the other side, so this is a defense. And I discussed with others, obviously it's still early days, and people say that, no, this is not a defense to payment adjudication. And others said, and I thought, okay, don't want to take a chance. I just valued those defenses on evidence. And if it passed, it passed, it failed, it failed. I think that's what I wanted to bring this evening.
Okay, so smash and grab rears its ugly head again.
Julie, if I can just add.
Please do.
Like Mo, I'm a panel adjudicator. And what we are finding at the moment is that adjudications are becoming far more legal and difficult. What I've found now is I don't think I've been in an adjudication that hasn't gone beyond surrend joinder. So for those of you who don't know, we have a referral followed by a response and a reply, but then it can go beyond that. And I've got ones that go to rejoinder, surrend joinder, rebutter, surrebutter. I can go on, and they can go on for months. And I mean, I've got, and my wife isn't too happy about this, I've got rooms filled up with files because of the amount of paperwork that is being issued. And what it identifies is that within these big adjudications, time and time again, there are issues of jurisdiction being raised. I would say it is more unusual not to have a jurisdictional challenge raised. And they're raised on many, many issues, including, as Mo has quite rightly identified, natural justice and the right to run defences and otherwise. And what it's showing is that if you're going to get in an adjudication, you have to define this dispute clearly. And that starts off from the notice, because it is trite law that the notice sets out the confines of the dispute. And then it can be expanded by agreement, by conduct, in effect, by the parties in dealing with further issues in the response, referral, reply, and so on. And the important thing is that when you're involved in an adjudication, you are entitled to and must be allowed to run any defence you want. That was a case of Vasco versus Cantelot. So anybody, when they're involved in a dispute, is going to raise anything they possibly can, and you need to be aware of that. So if you're going to start on an adjudication, do be aware what you may get involved in, and make sure that you're fully informed before you start and that you confine the dispute properly.
Okay. And a good way to find out what you should be doing during adjudication is to log on to those adjudication matters seminars. I think the next one's in March. So yes, that's a little advert for you there, Mo.
Thank you.
Okay. Meanwhile, Mr. Sharp has been looking at the joys of Brexit and any impact it may or may not have had on the construction marketplace so far.
John, just for my own information, what is Brexit?
It's the thing we used to talk
Haven't heard
about
that.
before coronavirus.
Oh, right. I just wondered what it is.
You remember what it
in the
was?
back of my memory.
I gave a seminar
Well, the
last
best-
week on Brexit and the likely impact that it's going to have on the construction industry. It is very early days. The deal was only done in the dying days of last year. But I think there's a few things we can look at now that are going to cause problems. The first one is, and this was asked of me by one of the attendees at last week's seminar, and it was, can we throw away all our EU rules? So do we have to abide by them anymore? Well, the answer is simply no, you can't, because most of the EU regulations are now enshrined into English law, either by statutory instrument or by act. And therefore, no, at the moment, they still apply. Now, over time, I'm sure some of them will go. The advantage now is that you will only be given new regulations by the UK government. So, but you can't just ignore previously passed EU regulations because you suddenly think, well, that's it, we're out of the EU now, I can ignore them. You can't. And the government will say, no, you definitely can't, because it wants a level playing field between us and Europe. Secondly, there may well now be supply issues for reasons I'll come on to in a moment. The logistics side of things has changed actually quite dramatically. And whereas if you had two competing orders, one from an EU country, say you're manufacturing something in Germany, you've got two competing orders. You've got one coming in from the UK and one coming in from the US, for example. Now, you would naturally probably prefer the UK because it's a simple matter. You simply put the stuff on a lorry, send it to the UK, thank you very much, done and dusted. But now, the reasons I'll come on to, there are border controls, it's not as simple as that anymore. And if the US price is slightly higher, you might think, well, I tell you what, it makes no difference now, I'll do the US one later. There's been an issue in particular with wood products now going out to the US before they're coming here. That brings me nicely on to the question of logistics. Have no doubt that we have left. We are operating at the moment at about 50 to 60% of normal freight traffic because of the pandemic. Yeah. But exporters have had to, the logistics companies have really had to adapt and adapt quickly. Now, we're actually quite fortunate that we're in this situation because it's given the major logistics companies time to adjust to the new regulations. In particular, customs form. The agreement we have with the EU, by the way, only covers goods wholly manufactured here and wholly manufactured in the EU. If you are using components from another country to make, I don't know, bathroom pods, for example, and they come from Korea, that's going to be taxed. You may need the assistance now of what used to be called customs brokers. The world has seriously changed and disruption is possible. There is no two ways about it. We've already had threats from the EU in relation to the Northern Irish border when we thought we were getting rather too good at vaccinating people. That will not be the last time this is raised. Real borders are now in place. Certain goods have to be checked within warehouses when they arrive to make sure they conform to EU standards. So it is going to be a really, really big change. Don't underestimate the logistical problems that will arise when we are back to 100% traffic. And at the moment, guess what? There's no people. No one's going abroad. And what do people normally cause? Problems. So there is going to be a real issue. So the advice has to be at the moment, build in time for your new contracts if you are thinking of getting in products from the EU. There may well be a delay when we are back to more or less maximum capacity. Secondly, plan in advance. Don't leave it to the last minute now to order your supplies from Europe, because they may well start preferring other countries over their former European member. Thirdly, think now about getting some goods in transit insurance. Because it's available at the moment, it's not a problem. There aren't any problems particularly. So buy it now, because it's probably going to be cheap. Because come March next year, which is about the time when you will be able to compare it to, say, March 2019, I think you will find that there's going to be a significant difference. And the logistics industry, for once, is not shying away from this. It's not saying, there'll be no problems at all. Don't worry about it. We've got it under control. There will be. And the best website I've found that deals with it is DSV Global Transport and Logistics website. It's interactive. Yes, of course, DSV are saying, we can solve all your problems. Don't worry about it. But they don't shy away from the issues that are going to face the import of goods. So not only might you have supply issues, you might have problems getting them here. The same will apply the other way around. Getting stuff to Europe, you may face delays there too. So buy time in your contracts, get some insurance, and plan ahead. But without any shadow of a doubt, the biggest problem facing construction going forward is going to be labour. Absolutely no doubt. The construction industry was already facing skill shortages. 15% of the people employed in construction at the moment are now over the age of 65, which of course is no age these days. But the construction industry has not been good at attracting younger people to come in to the industry. It doesn't advertise, come to construction. We're marvelous, we're wonderful, you'll see the world. You know, it's a bit more difficult, I accept. You know, you'll see the inside of a JCB digger. But the industry has not been good at attracting young people to come in to the business. There's a gender equality issue still. And in addition, younger people don't feel necessarily that their digital skills will be used desperately well within the construction industry. So there was already a skill shortage before Brexit. 60% of the employment growth in this country between 1996 and 2018 came from abroad. Now, guess what? 3/4 of that, there's been a 3/4 decrease in that figure since 2017. there's been a mass exodus of people from this country during the pandemic. And the new, and I looked at it the other day, the new coming to this country, I'm not quite sure what your immigration system, you need a degree in maths, engineering, and law to even get close to understanding what it's all about. It is a points-based system. The best I can make of it is that you will need to be sponsored by somebody. You will have to have an income of in excess of £26,000. I think that's a guess before you'll be allowed to come. And that's only if you're a skilled worker. And this was really difficult. I looked all over the document for the definition of a skilled worker. Now, I'm assuming that a fully qualified carpenter in Poland who has the equivalent of, I don't know, City and Guilds here would still be classed as a skilled worker. Well, I can't find a definition of it. Also, a highly skilled worker. They apparently can come, but there's no definition of that either. So I think what's going to happen is it's going to be extremely difficult for the construction industry to get in the general labourers that it needs to operate on a daily basis. So the advice would have to be from me at the moment, looking at this until it settles down, unless we get some passport like the agriculture industry has to allow in migrant workers during the peak periods here, unless we get that, there is going to be a very serious shortage of labour in the construction industry within the next, I would have thought, 2 to 3 years. So the advice has to be, watch the size of the project you're taking on, because will you be able to find the labour to honour your contractual obligations?
Okay, thanks for that.
Add a few things to what John has said. Agree totally with what John is doing, but no doubt those that are listeners at the moment will instantly be thinking about extensions of time. Now, what I would suggest to you is that it is very unlikely that you will be able to seek extensions of time, because John is foreseeing this. So it is not force majeure. For those of you who use JCT will be only too aware that it is nearly always crossed out that delays caused by a lack of labour or inability to procure materials, they're crossed out. We've got NEC that provides for an extension of time for matters that are effectively beyond both parties' control and that could not have been foreseen. But these can be foreseen. So the reality is that it is very unlikely that you'll be able to claim extensions of time for these events. However, I would suggest to you there are some things or precautions that you can take. And that is particularly with regards to the production of your programs and when agreeing, as John has quite rightly said, the period for the construction of the works. So once you've assessed what is the contract period in the contract, what you should be doing is producing a program that helps you and assists you if you are delayed. And there are some very simple rules. Number one is, clearly, if you're going to be ordering materials, placing subcontractors and the like, what you need is the necessary information. So when you're producing your programs, and particularly under the NEC, for example, make sure that the programs you produce show the issue of this information as early as possible. Include on your programs procurement periods, delivery periods, importing periods. Put all these periods in the program so that it can be clearly seen. But what we're going to identify is that if there are information first required before you can place the necessary orders, which will be particularly the case with things like provisional sums and PC sums, make sure you include the period at the beginning of the program. So, it's always been the case, but I'll emphasize it more than ever. Make sure you properly produce your program, because your entitlement will be based upon your program. And for those of you who have listened to a number of my courses on programming and planning, you will have heard me say this time and time again.
And remember, I mean, I do not want to be equally a doom and gloom merchant entirely. It is quite good that we've got this 50 to 60. It's allowing the logistics industry to adjust, to get used to the new customs forms, to get used to the new declarations, to get themselves the necessary certificates. But it doesn't take much. D&B are one of the biggest logistics company in the world. They say there will be problems. They've no reason really to say that. They address the issues head on, and also they have a question and answer website. So if you've got issues, they're very good, there's no charge, at answering those. But I have no doubt that there will be issues.
Okay, there's a fair warning there from all of you. Someone's just asked a question. With the apparent change in the form of government from a parliamentary democracy to a more authoritarian state, the end justifies the means ethos, with decree by press conference or otherwise, and the issuance of regulations without debate, etc., do you envisage any detrimental impact on the construction sector in the short or long term as a result?
I'm not
Wow.
sure I understand the question to start with.
Don't all rush.
I think the simple answer is no. There is going to be a number of impacts upon construction. I think the first thing is, and my colleagues and I, we are of the maturer years, and sorry, John and Mo, for saying that, but it is true. And we've seen many, many recessions over our time. And this is possibly one of the first recessions where the construction industry is arguably one of the least affected. Yes. Many construction projects are ongoing, but I know to my cost, most of the pubs are closed. It is a completely different situation than the past. So, what happens generally doesn't necessarily dictate all sectors. So construction at the moment seems to be continuing. The government has made certain statements about stamp duty and like, which is keeping the property market reasonably buoyant. So far as I can tell, having spoken to many of my clients who are contractors, developers, consultants, and otherwise, they are all busy. So at the moment, there hasn't really been a major reduction in the construction output. Indeed, many of the contractors I've spoken to saying things are going a little bit better because they're better organised, mindful of coronavirus restrictions and the fact that the roads are less busy. So I think the first thing is at the moment, the construction industry seems reasonably resilient, and there seems to be ongoing instructions moving forward. But as John has identified, I think there is a distinct possibility that there will be problems with both labour and material in undertaking works. And it really worries me, and I'm extremely concerned that I could see there being lots of claims. And obviously, I wouldn't want to see that. But it's, that's what I think is likely to happen. But I don't think it's by government intervention or the way the government is working. I think it is just dictated by the market. It wasn't long ago that everybody was partnering. I haven't seen a partnering agreement in years. Contracts are becoming drafted far more aggressively in the past. So I think it's more that people, prices are slowly going up, but they're still tight. There is concern, but I don't think the industry generally will be affected by such matters.
Just to supplement, Richard, if I may, that if the question is that would an authoritarian government have less construction in a market? The answer is, look at China and Middle East. Last 50 years, the largest sort of section of construction globally is in China and the Middle East, and all of them are authoritarian governments, and they don't have any democracy whatsoever. So it's probably unconnected. It's to do with the government the day, what they are doing to support or not support construction, not what the form of the government is.
On a more general point, I don't think any government in the world has had much option but to adopt the stances it's taken. Every government has a duty to protect its citizens, and they will say and argue that the restrictions that we've all been subject to have been necessary. If I have a slight concern, it's whether or not they will all be fully released. I hope they will be, but as Richard and Mo have said, it's not going to affect the construction industry. The acts of the government at the moment, the one thing they are doing is promoting the construction industry.
Okay, thank you very much, gentlemen. We don't have any other questions on that topic. We did have one more question. Someone was asking about, and I'm not sure which of you gentlemen would like to take this, the legal interpretation of defined cost. You mentioned NEC contracts earlier. What's the legal interpretation of defined cost under an NEC contract?
Okay, I'll pick that one. I think it is wrong to say legal interpretation. The NEC actually has a section where it has defined terms, and one of the terms that is defined cost. I'm not sure I should have kept using the word defined there. Defined cost is with capitals, and any words that have capitals are given a definition. And again, for those of you who are of maturer years, will remember that the term defined cost replaced the previous term actual cost. And looking to obviously confuse everybody, let me just explain that actual cost is an actual cost. And indeed, you have forecast actual cost and the like. But recognizing that the term actual cost was confusing, in the more recent forms of NEC, it's been changed to defined cost. And the term defined cost is defined in each of these 6 options. And very simply, in options A and B, defined cost is the costs that are determined from the schedule of cost components. In the later options, which is C, D, and E, which are target contract and cost reimbursable, defined cost is the cost of subcontractors and the like. But what you will find in many of the NEC forms of contract is that there is a secondary option, option Z, which is amendments to the other provisions, and the term defined cost is almost always amended. And indeed, quite often it includes that the defined cost is a schedule of rates that you find in the contract data. So in very simple terms, when you're looking to find what the meaning of defined cost is, you need to go into clause 11 where it is defined.
Okay, I hope that answers that question that we had in. Right, gentlemen, it merely remains for me to say thank you very much for your time and your expertise. Thank you to everyone who's logged on tonight. We hope you found it useful. Some fairly wide-ranging topics there. Mo, we see you next with your adjudication matters, and that one is drafting a claim or response. That's on the 11th of March. John, you're doing your insurance on the JCT contract on the 24th of March, and then Richard with your construction essentials, the latest in that one, which is extensions of time and proving delay, which we touched on earlier. So again, if anyone would like to book to log in for any of those events, please drop me an email, seminars@silverllp.com. And as always, each of our presenters' details, if you wish to contact them directly about anything you've heard tonight or any other matters, can be found on our website, www.silverllp.com. So thank you very much, gentlemen. Thank you to our audience, and we will see you all again soon. Thank you, gentlemen.
Bye-bye.
Thank you.
Thank you, Julie. Thank you.